Hello, my name is Joseph Doritas. I am a criminal defense attorney in Delaware County, Pennsylvania, and I'd like to explore a problem today that I think is very pervasive but very subtle within our criminal justice system. This is a problem of our country's Black leadership and probably to a lesser extent Latino leadership ignoring certain institutional racism problems that are arising in our criminal justice system. I think there's an idea among minority group leaders in our country, and again, I pose this to both Black and Latino leaders. The idea that I think is out there is I need to show the white population that I'm going to be just as tough on my fellow citizens as they are. As I say, it's a very subtle, very pervasive problem, but it's leading to massive injustices in which not only the defendant suffers, but even the defense attorney can be penalized for asserting the rights of minority group defendants. In May of 2013, I was fired by the Office of the Delaware County Public Defender for defending a Black teenager. I went to a preliminary hearing and I tried to question the cop on the circumstances of this teenager's arrest. The DA objected, I was overruled, and when the hearing was over, I filed a habeas corpus in the Court of Common Pleas of Delaware County. I was able to file that motion, but I was fired before I could argue it. Eventually, I took that case up to the federal judiciary. The caption of the case is Doritas versus Roger, Roger being the man who fired me from the public defender's office. I eventually settled that lawsuit, but many interesting things happened before I settled it. I had also sued in the Pennsylvania judiciary for unemployment compensation, explaining that I had been fired from my job for discussing with township officials and county officials what was going on in the public defender's office. I went to two officials of the county, both of whom promised that they would investigate the matter, and neither of whom ever got back to me. Several months later, I was fired. The problem here is that we're seeing institutional racism, a very subtly designed tendency in our criminal justice system to evade the issues that would lead to acquittal of minority group defendants. This is a problem that's actually designed right into the system. And you're prevented from appealing these matters because you can be fired even for discussing them, as I did, with county officials. Prior to the firing, I had been removed from my trial team for demanding evidence in my clients' cases. Defendants are always entitled under the Sixth Amendment to the Constitution of the United States and many provisions of the Pennsylvania Constitution to demand evidence of their guilt. I did that in every case, and I was removed a year before my firing from the trial team. Again, when I tried to complain about this, I was promised an investigation, but nothing ever happened. Now, when my case eventually went up to the federal judiciary, and then from there to the Third Circuit Court of Appeals, I was told that I had no right to discuss these matters, and my firing, therefore, was the proper way to proceed. The Pennsylvania judiciary said the same thing. My case also went up to the Commonwealth Court. Commonwealth Court said, no problems here. So what we need to start dealing with is a much wider problem, a jurisprudential problem in the law, which regards the functions of criminal defense, in my very strong opinion, as being almost an inconvenience to the court. The key to these cases, I think, was fear. That's what had everybody so terrified. Every judge, every court, with the exception of Judge Cynthia Roof on the Philadelphia, the Eastern District of Pennsylvania, based in Philadelphia, was reacting to my assertions with a sense of alarm, a sense of really outright horror. And I think that the mentality that emerged, the attitude that was taken is, well, Doritas is lying because he has to be lying. Nobody would ever do anything so horrible as this. Nobody wanted to confront the fact that in the year of our Lord 2013, a criminal defendant can be railroaded into jail simply by firing, or in my case, just by demoting the attorney. This is something that I think had the judges in the courts horrified. And I didn't blame them one bit, really, because this is a massive problem in the law, and the only way it's ever going to be cured is with constitutional amendments. The practice is they're clearly guilty. They don't need to see evidence. So if you can railroad someone into jail simply by firing or demoting the attorney, you have no criminal defense in that jurisdiction. I can tell you in Pennsylvania, criminal defense is a completely and totally political exercise. The public defenders are completely at the mercy of the political party in whatever jurisdiction they are practicing. In the 2 counties that I have now been fired from, this was always the Republican Party, getting mad at me and eventually firing me because I was advocating their cases in the courts. That had them scared. And the solution was to simply call me a liar. The idea was Doritas is lying because he has to be lying. Now, I'm concerned that Black leaders, and to a lesser extent Latino leaders, are ignoring this problem. I don't think there's any such thing as black racism. I think that would be a very ugly term for anybody to use in the criminal justice literature. But I do think that there's a sense of irresponsibility that pervades the sociology of the law, the sociology of criminal justice. The group dynamics are such that you can't really complain when you see an injustice being perpetrated against the defendant. And the reason you can't complain is because it isn't good for defendants to fight their cases. It's the old equation that plea bargaining replaces evidence. We no longer demand evidence from our courts. We simply plea bargain the case. Now, what this translates into is something known as constructive denial of counsel. The lawyer is present in court, but he's basically just a phantom. He's standing there beside the defendant, but he's not allowed to ask for evidence. This has been recognized in our previous jurisprudence. In my case, what had scared everybody was an episode in Pennsylvania legal history known as Kids for Cash. Kids for Cash, some of you may recall from your reading of the literature and your reading of the media, was the enormous scandal in Luzerne County where 2 juvenile court judges were discovered to have been sentencing juveniles over and over, thousands of juveniles, to 2 juvenile facilities in which they had a financial interest. Basically, these juvenile facilities were owned by these 2 judges. So the judges, of course, had a financial draw in sentencing juveniles to these institutions. What's interesting about Kids for Cash is that originally the Pennsylvania Supreme Court did nothing about it. The Department of Justice had to step in. The Pennsylvania Supreme Court only investigated after the Department of Justice had brought federal charges against these 2 judges. So this, again, was constructive denial of counsel. The lawyer goes into court, but the lawyer is not permitted to speak. The lawyer is not permitted to ask for evidence. He's there, but he's just a phantom. In Kids for Cash, the juveniles were waiving their right to counsel, even though in Pennsylvania, as in most jurisdictions, juveniles are presumed indigent and automatically qualify for a public defender. It led to an enormous scandal. 2 judges sentenced, one of whom I believe went to a federal prison for 28 years. But again, I emphasize, the Pennsylvania Supreme Court said, no problems there. Pennsylvania didn't jump into this matter until those judges were well on the way to federal penitentiaries. This is a problem that I believe is an enormous crisis, not only for criminal defendants in Pennsylvania, but probably throughout the nation as well. The public defender needs to be completely protected in his or her function as an advocate to the court on behalf of the defendant. To do that, we actually need a constitutional amendment which says that public defenders will be able to discuss their cases with the judiciary and with county and state officials when they see an injustice taking place. In my case, the Third Circuit Court of Appeals said, this is not a problem. Again, I emphasize, the idea was Doritas is lying because he has to be lying. Nobody would do anything so horrible. Even though my boss admitted that he took me off the trial team to prevent me from asking for evidence. Now, if this problem continues to germinate, people are never going to be able to see evidence in their cases. they're going to have to bargain the case, or they're going to have to take the chance of going to trial and possibly listening to fabricated evidence in order to get them convicted. We've already seen that in a New Jersey case called State versus Patton, where the police actually recorded a false confession to induce a defendant to confess his case. In that case, it was murder. The New Jersey Supreme Court said the confession is dismissed, so is the verdict. The defendant must go free. What was really alarming everyone in my case was the possibility of a stampede. The Pennsylvania Supreme Court and the Third Circuit Court of Appeals, which is also based in Philadelphia, were afraid of a stampede to the media courthouse in Delaware County, Pennsylvania. They understood that if they gave me that decision, thousands and thousands of defendants who never saw discovery, that is to say, never saw proper evidence in their cases, would be able to go to the court and petition for a reversal of their convictions. In Kids for Cash, 2,400 juvenile convictions had to be thrown out by the Pennsylvania Supreme Court. That has never happened in any other state in the United States in our entire 250-year history. This is a problem which calls for massive intervention by Black leaders, Latino leaders, and of course, anyone concerned with indigent defense. Private defense attorneys also sometimes experience this problem. One of the practices in Delaware County is to jail a defendant on a bail violation once they ask for a trial date. I've seen it happen in my cases, and I've seen it happen with private defense attorneys. The solutions to these matters are not to petition our courts, because our courts have made it very clear that they have no intention of rectifying this problem as long as they can get the guilty pleas and warehouse our defendants. This requires legislation. The Black leadership, the Latino leadership in Pennsylvania and throughout our nation has got to start advocating for proper terms of criminal defense and indigent defense, specifically the security and safety of indigent defenders, public defenders, when they are advocating for their clients. That means revising the Pennsylvania Rules of Criminal Procedure. That means amending the constitutions of the United States and the Constitution of the Commonwealth of Pennsylvania. It has to be legislated. For example, the Miranda rules are completely optional for the police. The police do not have to read the Miranda warnings unless they believe that they are going to have a defendant who will be able to demonstrate that they were in custody. That's why the cops will always warn defendants that they're not in custody and can leave at any time. We must legislate the Miranda rules. We must write it down on paper. We must say that in every case, no statement of a defendant comes into the trial that has not been signed off by the defendant. That requires massive intervention in our rules of criminal procedure. The judiciary has made it clear again and again that they're not going to offer that protection without directions from the legislature, so the legislature has got to be the starting point. I thank you for your attention.